And if you would hit that, thank you very much. Good evening, ladies and gentlemen. Today is February the 23rd. This is the Housing and Real Property Subcommittee. And today we have on our agenda 4 bills. However, because of the time frame that we are meeting this evening, House Bill 140 will be discussed at a later time. We have amendments for 140 that I have that might need some additional discussion, but because we're late in the evening, we're only going to be discussing 3 bills instead of 4. All of you have received information from Matt relevant to these 3 bills, which includes amendments that have been submitted. And what we're going to do first off is start with HB 40. And there was some discussion last week relevant to the notices of, oops, I got the wrong bill up there. Discussion last week about disclosure of information prior to signing of an agreement. And there has been an amendment that has been offered. And I'm hopeful that this amendment will be to the delight of the subcommittee members. I may also add that a bill very similar to this one, HB 30, last year was voted favorably out of the House 137-0. 137-0. Did I say 137-0? So anyway, Matthew, if you would discuss, if you would, Matthew, and all of you received this amendment. Matthew has handwritten in red in terms of how we believe that the discussion from last week could be settled for everyone's pleasure. Can you go over that amendment, please, Matthew?
Yes, sir. So I'm referring to HB 40-373-421-1. And the copy you should have should also in the file name say with Michler handwritten changes. And you'll see, as Delegate Holmes noted, some handwritten language in there. So at the end of the last discussion of HB 40, there was this question of disclosure of certain information of the intention of the board of directors to enter into an agreement for the purpose of settling a disputed common element warranty claim. That language was added as new, this new item 2 here that you see on page, let's go to the reprint. Page. All right, so in the PDF document, it's page 5 of the PDF document, and it's towards the top third of the page. Unfortunately, there aren't line numbers the way the amendment went in. And then there's an identical change on page 6 of the PDF document about midway down. That whole paragraph there that you see is new language that was suggested to fix the gap as identified by Ms. Strawn. My handwritten changes just correct what believed to be kind of an oversight. And I've worked with Ms. Strawn as well as CAI to clarify that this particular notice provision would apply.
Just tell me what time the email came so I can find it.
This would be, I would say yesterday around noon.
Okay.
I've tried to reply in line with all the amendments so that they should all be in one extensive email.
Okay.
And I can, you know what, I could share the amendment.
Why don't you send, can you send it again right now? That would be like the easiest thing.
Yeah, that'd be a lot easier. Thanks.
Share the screen or send the amendment?
Both.
Share the screen. Share the screen.
And send it.
Let me start with the sharing of the screen, and then I will resend the amendment.
Okay.
Sounds good to me.
Okay. So your indulgence, I'll leave the language up. So you can be looking at it as I resend this.
Right. And I'm sorry, I probably should have asked Matt to do that in the very beginning. I'm sorry. But this is a good way to proceed. That way everyone can see it. Go ahead, Matthew.
So anyway, yes, as noted, that the handwritten change here, what this does is just clarify that this duty to provide a statement of the intention of the board of directors to enter into an agreement for the purpose of settling a disputed common element claim applies after disclosure occurs to the unit owners in accordance with new language in section 11-134.1 C2 of this title, but prior to execution of the agreement. And so it's that window that Ms. Strawn identified as concern.
And I think what we attempted to do here was try to make sure that we kind of split the baby in half to make sure everyone is being satisfied with how the disclosures are taking place. Any questions on the amendments, on that amendment?
Ladies and gentlemen, you should receive very shortly the amendments, if you haven't already.
Can I get a motion on the amendment?
As long as this is part, I'm sorry.
Go ahead.
As long as it's part of what was worked out with Karen Strawn. And
Okay, can I say,
Hang on a second.
Okay.
Finish, Delegate Frost, saying what you said.
No, I just said as long as it was part of what was worked out with Karen Strawn, and she nodded her head, so I'm satisfied.
Oh, okay. Delegate, Bob, go ahead.
if I just would like to go on record by saying that on behalf of the builders, we still don't believe that it's appropriate that prospective buyers that don't have an ownership interest are now going to be given this information about a settlement which hasn't occurred, but something that hasn't been signed. And while I understand that this is not going to be given by this is on resale, not on the sale by the developer, but we think it's detrimental to the existing unit owners. If I have a contract for sale, we were fine with saying to the buyer, when you get the notices of the declaration, anything, you get notice that just like you do of everything else, that there's been a settlement agreement that's been, executed. And you can question, if you don't like it, you don't have to buy. But this says we're going to now give them notice of a prospective settlement, something that hasn't been signed. And to me, it just seems to me that it's going to negatively impact, resale. It's going to raise lots of questions. There's not going to be any confidentiality at all. And we just think it's a mistake, and we're opposed to that. So I just wanted to go on record by saying that.
Appreciate it, Bob. But it also, the amendment also talks about the disclosures after disclosure to the unit owner. So the unit owners have already been notified. So this is after that. Let me go to Delegate Lehman.
Thank you, Mr. Chairman. So first of all, this handwritten amendment doesn't look that different to me, rather than prior to it's after. But to Mr. Enton's point, where is their prospective buyer language? And what about somebody that's actually scheduled to go to closing? Do you not think anyone in the process of purchasing a unit has any right to information about a pending settlement?
Let me answer your question. The question you asked was about a prospective buyer.
Yeah, where is that?
I'm sorry. Yeah, the question you asked was about prospective buyer. This is information that is going to be part of the resale package. If you're a prospective buyer, you get the resale package. That's the answer to that question.
Okay. I asked where that wording is because I don't see it right in front of me, and that's the issue Mr. Enton is raising. But is there a definition of a prospective buyer, Chair Holmes? Is it just anyone that expresses any interest at all? Someone that comes to an open house and is interested in a unit, or do you have to be further along in the process of, offering a contract, or what? How is that defined?
That's I don't think there is a definitive definition for prospective buyer.
I respond, I think I can answer the question.
Go ahead.
Chairman.
Maybe there should be.
So,
but-
if you scroll down, if Matthew will raise back up, this will become part of the disclosure that's given, okay,
In the
on
resale package?
resale.
In the resale
Yes.
package, right?
Right. So that's what is given, if you read it. A contract for the resale of a unit by a unit owner other than a developer is not enforceable unless it has these different documents in it, and a certificate that contains this, a certificate contains that. And now it's going to have a certificate in there that says that there is a agreement, which has a potential agreement that's been furnished to the unit owners settling claims.
So that,
So in other words, sorry.
So there has to be, in other words, there has to be a contract on the table.
Yes. Yes.
Okay, thank you. That answers my question. Thank you, Mr. Chair.
Delegate Terrassa?
No, I was just going to go back to the fact that before amending this at all, and it's been significantly amended, didn't you say this passed as it was filed last year?
None of this language was in last year's bill. This language is.
Right,
it's been
but
added.
it's been amended. I thought it was amended in conjunction with your working with the sponsor in part.
We did a lot of work on this. We're the ones that offered
You want to
the
change this.
amendments. We're the ones that offered the amendments to add these disclosures in the documents. That was not in the original bill. The original
Right,
bill was
I
very
understand.
simple.
You asked for a bunch of changes from as I recall, some of which were going to sort of invalidate the whole thing. And
No, I never asked for any changes. that were going to invalidate the whole thing.
Bob, hang on,
That's
Bob.
incorrect.
Bob,
That's incorrect.
Bob,
Okay.
That was
Yeah.
my recollection, because otherwise I think we would have just voted for it as is.
May I,
I would be happy to see it pass as was.
As
All right.
was.
all right,
No.
hold it, ladies and gentlemen,
I'm
ladies and gentlemen. Hold on. This is not a dining room table at Thanksgiving. We are not going to be talking over each other. We're going to be raising our hands and we're going to be called upon to speak. This is not Thanksgiving dinner, okay? I do appreciate it. Thank you so very much. Delegate Terrassa, please continue your sentence, your statement.
So I'm ready to move forward I'm ready to make a motion and move forward with it. I mean, certainly you've got to listen to everybody else on the committee.
Is that a motion, Delegate Terrassa, for the amendment?
I'll move approval, but will that also give Delegate Healy the chance to say something? Because she's.
Delegate Healy.
Thank you. I'm confused. I'm sorry. I really, not quite clear now. I thought I understood. So the status of this, what we have before us with this amendment, handwritten amendment, does this allow for a person who is buying the property, who has a contract and is going to closing, to know that there is a settlement in the works?
Yes. And the language specifically state, and let's go back to what question Delegate Terrassa had. This information is given as part of a resale package. When you sign a contract, and I'm just going from memory here, so I don't have all this in top of my head. When you sign a contract, you get a resale package. I think it's 7 days after the contract is signed or a certain amount of days before you go to closing. That is called the resale package.
So you have time, I'm sorry, can I just ask?
Yeah,
I just wanna-
sure.
Okay, so you would get this as part of that package,
That is correct.
and you would have time to read it over before you go to the final settlement, and you can say, this is not acceptable to me now.
That
And you
is,
can back out of the contract.
that is exactly correct. And in addition to that, Delegate Healy, if you do not receive this resale package, you can cancel your contract.
Okay, so that was my main concern, is that I don't think it's a good idea for it to be just broadly out there for anybody who happens to go to an open house and see all this information. But
That is correct.
if they're serious about it and and they're going to be putting an investment into the property, then they should have access to even the fact that it's something that's pending.
And that is exactly what this amendment says.
Okay, then I support the amendment. Thank you.
Is that a motion for the amendment, Delegate Healy?
Based on our conversation, yes.
Is there?
Second.
Oh, I'm sorry.
Second it.
Delegate Fraser Dogg, DFH.
Yeah, just to be clear, because just want to reiterate what Delegate Healy just said, just to make sure, because I kind of got the distinct impression there's some differences between what Mr. Enton is thinking in this. So if I'm a potential buyer and I'm looking at a particular unit or property or whatever it may be, this says that if there's something pending, then you get to find out about that when? As a potential buyer, that's seriously, or is just as a packet as I'm walking through and the packet has it right in it immediately? When exactly does one find out that there is potential litigation of some kind or something pending?
Sure. And it's part of the resale package. And what Matt is scrolling to now identifies the time frame. Where is it identified here, Matthew? Right there.
15 days prior
Right
to,
there.
not later than 15 days prior to closing.
Mr. Chairman, can I
So-
just clarify something there?
So
I
so
think
let
what's-
me finish. So what you do is, once you sign the contract, you get this resale package and you see the timeframes of the resale package. And if you are not, and in that time frame, if there's something in there that you don't like, then you can cancel the contract. And if you do not receive the resale package, you can also cancel the contract.
Okay, so this is not, so Mr. Chair, so this isn't just lying around as you're taking a tour, you can just grab it and it's in
No.
the package.
No.
Okay, okay, that's I just wanted to be explicitly clear on that. So I go in, I grab the resale package, I'm like, hey, this looks pretty cool, I'm really interested. I make an offer and then.
No,
and then-
you got it backwards. You got it backwards. You make an offer first.
Right,
As you look at, you go to look at the condo, say, hey, looks this great. You don't get the resale package. You just
I
walk in
understand.
there. So you have to sign
I
a
understand.
contract.
and then I understand, I'm trying to go through the
Oh, yeah.
story. So I go through, I'm like, this looks great, I make an offer, then I get the resale packet.
Yes,
And the resale packet would then subsequently disclose this potential, this as an issue.
yes, sir.
Okay, so wherein lies the difficulty with Mr. Enton? Does he not want that?
Could I just say, could I
Later?
just respond? Could I respond? What you just said is exactly what I said. I understand that. The difficulty that my client has raised is they don't think it's appropriate, and it's your decision, not ours, obviously. They didn't think it was appropriate for someone who has a contract to buy to get this disclosure. This disclosure should go to the unit owners, not someone who may go to closing or may not go to closing. And we think that it's going to have a detrimental impact on the resale marketability, because when people get this, it's going to open up a Pandora's box. It's one thing to disclose to the unit owners from the board, and they're accountable to the unit owners, that there's a potential settlement. What do you think about it? We thought it's a different ballgame to disclose it to someone who's not a unit owner. That was our point. I understand the concern.
So Mr. Enton, then based on that point, then the buyer would not get that information until after they've settled.
That is correct.
Yes.
Okay, okay.
And that's where the difference of opinion is.
That's what I thought. Okay.
Yeah, okay.
That's what I thought.
Doug-
I just wanted to confirm, not only for myself, but anybody else that had any thoughts on it. Okay, thank you.
Thank you, DFH. Delegate Terrassa?
Yeah, I'm like floored by this argument that it'll have a detrimental impact on the resale market, because the reality is, the problem is that there's a defect in the property that they're trying to come to an agreement on. And that defect is what the buyer has a right to know about. So from my perspective,
is that a second for the amendment, Delegate Trosser?
Yeah, I did second it
Thank you
already.
very much. So we have a motion and a second on the amendment.
Thank you.
All in favor of the, scroll back down to the amendment, if you don't mind, Matt.
Well, so just to be clear, the amendment is more than just that
Oh,
handwritten.
yes, that's right. I'm sorry, you're right.
The whole thing I sent you was amendments proposed by the sponsor.
And go through those if you don't mind.
Yes, sir. So. Okay.
And the amendments basically fall into the same line of discussion that we're having now in terms of disclosure. But go ahead, Matthew.
Right. So there are three amendments on the table. The first amendment is technical, makes changes to the purpose paragraph and function paragraphs of the bill as necessary to implement the changes of the sponsor's amendment. The second amendment requires certain disclosures to the Council of Unit Owners, a member of the public buying a condominium unit from a vendor, and a member of the public buying a condominium unit from a unit owner other than the developer, if the board of directors or the Council of Unit Owners enters into an agreement that settles or releases claims related to common element warranties under Section 11-131 of the Maryland Condominium Act. And then the final amendment is a request to add a sponsor.
Okay, so we have a motion and a second on the amendment. Karen Strawn, you want to weigh in your opinion on what is taking place here now?
I think that when we talked about everything the other day, all the changes that were made before were fine. The change that's being made now is the addition that I was requesting, which is what we're talking about, where they find out once they have a contract and once there's been disclosure to unit owners, then they would find out about it through the resale package. And so prior to purchase, but after disclosure to unit owners, they would find out about the execution of the contract being pending.
Okay.
And I just tried to clarify that it's this information here that I've highlighted and the attendant language down in the actual description of the notice, which is subsection G of section 11-135.
DFH, I see your hand up. Was that from previous?
That's from previous. I'm good. Thank you.
Okay. All right, ladies and gentlemen, we have a motion and a second on the amendments. All in favor of the amendments, signify by saying aye.
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 Any opposition to the amendments? Hearing none, have a motion for the bill as amended.
Move approval.
Second.
Second, all in favor of the bill as amended, signify by saying aye.
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 Thank you very much. Any opposition? Very good. Thank you very much, ladies and gentlemen. We will now go to HB. Let me pull up my sheet here. HB.
It should be HB
358.
358.
HB 358. And Matthew, would you pull that up, please, to share your screen?
Okay, so on HB 358, there were no amendments. Yes, I will pull it up and share my screen to show a copy.
Yes, just to show a copy of the bill. So we're all familiar with the language of the bill. What's going on here? Come on. HB 358. And HB 358 is the Maryland Condominium Act amendments to the Declaration Interests of Common Elements. And this bill basically is requesting that the authorizes the Council of Unit Owners of a condominium to amend the declaration by a vote of at least 60%. I thought it went to 100%. Oh, so no, it's decreasing from 100%. It's decreasing, the bill decreases the vote from 100% down to 60%. And if you recall, in the discussion at the hearing, there was opposition by, there was a letter of concern by the Attorney General's office There was opposition from CAI. There's also opposition by the Building Industry Association on this bill. And the Attorney General's letter suggested, well, the Attorney General is here. Karen, you want to discuss your concerns about reducing the percentage of the vote, Ms. Strawn?
Yes, the concern is that this is actually taking it from 100% to 60%, as we said, which is what it's doing is, we understand that 100% is difficult to get to, but what it's doing is actually allowing the common elements to be divided up in a percentage interest that's going to allow for the smaller party to be not given their value of their vote, basically, so that you can have a situation where you have you can have a situation where you have 60% of the people are townhomes and 40% of the people are townhome condominiums, and 40% of the people are more apartment type condominiums. And they might decide that they're going to switch the percentages of what the value is of each
Of the common
element.
Right.
And the 60% is automatically going to win if you change this. Whereas if you leave it at 100% or even something higher like 80%, that you would get a more fair and just result from the people. So that's why we put in a letter of concern.
And what I'm coming to you in a minute, Bob. And what Ms. Strawn is discussing, and I'm sure Mr. Inton is going to weigh in, the 40% kind of get the short end of the stick, and the 60%, as Ms. Strawn suggested, would obviously be getting a better end of the deal in terms of the common elements. Mr. Inton, you want to weigh in?
If I could, Mr. Chairman. So I did have a long discussion with the sponsor. We got on the phone with him and with the attorneys, with Michael Farber and Sheila Lynn, who are the attorneys with expertise in this. And I am pleased to agree with Ms. Strong, as I always am, that I think that this law ought to be left alone. The concern is that there's an imbalance. I guess in some of the bylaws or declarations, they provide that you pay your dues based on your percentage ownership of the common elements, and that's what he's after. The ownership of the common elements doesn't matter really if you own, 2% or 4%. You still have the right to use them. But it's because in some of the declarations and bylaws, my understanding is that the ownership then dictates what you have to pay in the way of dues and fees. And they want to be able to have 60% change the ownership in the common elements. And what I suggested to the sponsor is he needs to work with his attorney, and it's in his community, and try to amend the bylaws if you think that the dues paying arrangement is unfair. But you can't go back after the fact and after people have bought, and after from the bankers, we also raised the concern, after bankers have loaned the money, and now you're going to change my ownership interest based on the guy across the street's vote. And if he's got 61 and I got 39, now all of a sudden what I bought I've been divested, and that's not right. Yeah. But I think there is probably a way outside of the legislation to address the delegate's concern. And I told him we would be happy to work with him and take a look at the bylaws for his community.
Thank you, Mr. And quite frankly, I think the resolution to his specific issue in his specific community is in fact the bylaw, and not right. An attempt to address the state legislation, quite frankly.
I agree.
Delegate Trassa?
Thank you, Mr. Chairman. That may have answered my question. Because I I don't recall his testimony. He didn't submit written testimony from what I can see. All I could see is that there were some fine sponsors on the bill. And I was just wondering what the
What's
purpose.
the bill number? I'm sorry. Can you remind me?
358.
HB 358.
Yeah, well, one of the co-sponsors of this particular bill is would like to make a motion to move unfavorable. How about that?
Okay, then I will second
Second.
that.
All right.
That's fine. I'll second that. Or if Delegate Healy did, whoever seconded it.
That's
Thank you
fine.
very much. We have a motion unfavorable, and we have a second. All in favor of the unfavorable signify by saying aye.
Aye.
All opposed? The ayes have it. HB 358 will receive an unfavorable report from the committee. And now we go to the last bill of the day, which is, oops, I must have leaned on my laptop. The last bill of the day is what?
HB 537, sir.
HB 537. And on HB 537, ladies and gentlemen, that bill is a bill sponsored by Delegate Ivy, HB 537, that is correct. And Delegate Ivy did in fact submit an amendment to that bill just very, very recently. And the amendment that Delegate Ivy submitted to the bill is in an attempt to address some of the conversation that was had in the committee hearing. And in a nutshell, what the amendment does is to include, Matthew, why don't you explain the amendment? Explain the amendment.
Certainly. So the amendment does a couple of things. And from what I have read and understand of the amendment, as well as testimony offered on the bill, the amendment would incorporate some of the positions made by the Maryland Realtors. First off, the amendment adds a definition, specifically that definition is of cottage condominium. It would alter the inspection duties of DHCD under the bill. It would authorize a homeowner to apply for, and if anybody's following along, the amendment I'm referencing is HB 537-613-824-1. It would have been the last amendment I sent today. Does everybody have that, or would you like me to share a copy?
I think, Matthew, what I would like to kind of cut to the chase.
Okay. There are a couple more changes to the amendment.
Yeah.
Would authorize a homeowner to apply for a grant for an accessory dwelling unit owned by the homeowner, expand upon the types of primary residential properties to which the grant program may apply, and clarify that the homeowner's insurance policy requirement only apply if the property is required by a mortgage lender to be covered and applies as of the date on which the application for a grant is submitted.
Thank you, Matthew. And the major issue with this particular piece of legislation is that it has a $5 million fiscal note.
Oh, move unfavorable.
Mr. Celebrity?
Second.
All in favor of the unfavorable signify by saying aye.
Aye.
Is there opposition to the unfavorable motion? Hearing none, ladies and gentlemen, we will submit an unfavorable report on HB 358 to the full committee. And as I indicated earlier, because we're still working on discussions on amendments to 140, we will not discuss that this evening. As our friendly chairman always says, you are free to go.
Bye-bye.
All right. See you tomorrow.
Thank you.
Thank you very
Bye.
much. Bye-bye.